spinning plates and like a marching band, club band. Is that why you cut it last minute?
Yes.
So it was a
My
good
ego,
thing.
as you know, I always very much.
Well, we like the drama. Your brief writer shows it.
The show never ends.
All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Sias presiding, is now session. Please be seated.
Good morning. I hope everyone had a great weekend. Welcome to the First District Court of Appeals. Today is Tuesday, October 7th. We, in essence, have, let me count them, 1, 2, 3, 4, 5, 6 cases on the docket. 3 are going to be joined for the purposes of argument. The remainder, other than the last case, have submitted on the brief. So just so that you know, so when we are completed with your case, we're going to take a little bit of a pause. We'll stay on the bench, but there will be, Judge Krause will be joining us, and Judge Nestor will be departing. Okay, so for the docket, the 3 cases that we have that are joined for argument this morning, and if attorneys can please identify themselves and their readiness to proceed, are cases number C250068, Caitlin Boggs versus Durrani MD et al. Case number C250072, Amanda Koch versus Durrani MD et al. Case number C250275, Eddie Stallings versus Durrani MD et al. Good morning.
Good morning, Your Honor. Taylor Lovejoy, along with my co-counsel Philip Williamson, on behalf of appellants Dr. Durrani and Cast, and we're ready to proceed.
Okay, and just so that I know, are you the only one that will be arguing today?
Yes, sir.
Okay, no worries. Good morning.
Alan Stabman and Ben Moran on behalf of the 3 applicants.
Okay, and are you going to be the only one arguing, or are you splitting time? You will be the only one arguing. Okay, all right, thank you. So the next case we have is case number C250023, Matthew Burge versus Bethesda Hospital. This case has submitted on the briefs. Then we have case number C250090, Hans Gilbert et al. Versus Jason Welter et al. This is the case that we will be taking a little pause before the arguments. And the last case we have that has submitted on the briefs is case number C250136, State of Ohio versus Leonard Crawley. All right. So Attorney Lovejoy, whenever you're ready.
Good morning. Taylor Lovejoy on behalf of Dr. Durrani and Cast, the appellants in this case. May it please the court.
Would you like to reserve time?
I would like to reserve 3 minutes for rebuttal,
All
please.
righty. Whenever you're ready, you can start.
There are 2 things we know in this case. At a minimum, pursuant to this court's recent decision in Fenner, this court must remand to the trial court for consideration of the proper set-off amount that appellants are entitled to. We also know that this was a close case, reflected in the non-unanimous jury verdicts, as well as the inconsistent jury verdict that exists in regards to Ms. Boggs. Now, appellants have presented 9 errors for this court to consider. Rather than guess which error caused this confusion and inconsistency, we submit that the court should address every prejudicial error and instruct the trial court on remand on how to address those errors. For purposes of today's argument, I would like to focus on 2 issues in particular that are novel for this court. One being joint trials as it applies to a 3-plaintiff joint trial. This is the first time that
I want to make sure I understand when you said remanded for the instructions on how to handle, is it because you're saying they applied the wrong law and we should instruct them on how to apply the law? Or is it that you should win on the merits of your argument, which creates a different outcome?
So I apologize, Your Honor. I'm saying that regarding the Fenner, application of the Fenner decision, this court must remand to instruct the trial court to apply the proper set-off amount. And then in regards to the prejudicial error, we believe that there are some inconsistencies in some of this court's decisions. So we ask that the court would clarify what the law is, in particular, one of the issues being joint trials, so that that can be corrected upon remand of this case.
Okay.
Now, counsel, you said the distinction with respect to joint trials is here we have 3 versus 2. And my understanding is that the issue that we need to look at is whether or not common questions of fact predominate the case. Why does 3 versus 2 impact that?
Well, Your Honor, as appellants have stated in previous cases as well, we don't believe that there have been any common questions of law or fact, even when there were 2 plaintiffs. But I think what we can see here in the record is that now that we've progressed to 3, there's clear evidence that it confuses and prejudices the jury. And with each additional plaintiff that we continue to add, what's not to say that it'll be 4 or 5 next.
Well, we only have 3 here. And
Yes.
the question is it 2 of them have common questions of fact and the third does not, or all 3 have uncommon questions?
I'd submit that none of them have common questions of law or fact. So in this case, Ms. Boggs and Ms. Koch, I'll concede, were both minors at the time that their surgeries happened, but beyond that common issue, there's nothing alike between the 2 of them. All plaintiffs had different diagnoses. Specifically, Ms. Boggs presented with a degenerative disc disease. Her surgeries happened not only at L3,
I want to
L4.
make sure I understand, because I did review the filings on the jointer. I reviewed the transcripts of the hearings on the jointers. Was commonality challenged? Was the determination of commonality challenged? Because it was clear that the differences in the cases was being argued from the perspective of prejudice and how it would then invoke prejudice, okay? But was it also challenged on commonality?
It was, Your Honor. In particular reference to this case, it was challenged in defendant's pretrial memoranda in opposition to consolidation of the 3 cases. That can be found at Koch TD 80. It was also challenged in a motion in limine, which satisfies Rule 103's objection requirement. That could be found at Boggs TD 215, Koch TD 83, or Stallings TD
Okay,
140.
but basically it's your position that it was challenged?
Yes, it was. And then there were also various objections made on the record at trial on the first day in regards to that motion in limine, again stating that these cases should not be consolidated because there is not a common question of law or fact. And turning back to your question, Judge Moore, as why these are not the same, why there isn't a common question. So as I mentioned, Ms. Boggs had surgery at L3, L4, as well as L4, L5. That is distinct from the other 2 plaintiffs here that only had surgery at L4, L5. Ms. Boggs also, Ms. Koch also presented with a diagnosis of a congenital narrowing of the spinal canal. That's a specific condition unique to someone, or that can be progressed by someone that has experienced pregnancy. Ms. Boggs was pregnant twice during the time of her treatment under Dr. Durrani. Ms. Boggs was never pregnant and Mr. Stallings were never pregnant. So again, that is not a commonality between the 3.
How did that distinction, the pregnancy, impact the alleged misconduct by Dr. Durrani?
I think the way that I don't think that Dr. Durrani committed misconduct, but
That's why I said alleged.
I'm sorry?
That's why I said alleged.
Yeah. But why it's important here is that based on her pregnancies, she then presented with a specific diagnosis of this congenital narrowing of the spinal canal. Ms. Boggs and Mr. Stallings did not have that diagnosis. And
But isn't the issue the response to the diagnosis, the treatment that was provided? Regardless of the diagnosis, the allegation is that treatment provided was below the standard of care.
Yes, and I don't believe that the treatment was below the standard of care. I don't purport to be a medical expert, but the surgery that Ms. Koch had was in response to that specific diagnosis. It was a different surgery than what Ms. Boggs or Mr. Stallings had. Ms. Koch had a lumbar hemiolaminectomy, discectomy, as well as a bilateral surgery at L4, L5. Those are unique surgeries that neither Ms. Boggs nor Mr. Stallings had.
But isn't that the case in all of these issues around consolidated trials, that there are differences between the plaintiffs? One may be L5, L6, one may be L3, L4. Those commonality or those differences existed in other cases where we found that consolidation was appropriate, didn't it?
So I think that the court's position on that has changed, which is why we're asking the court to look at this issue today, now that there are look at this issue again today, now that there are 3 plaintiffs. Because in Jones, this court held that it must involve the same condition at the same level of the spine, but then subsequently in Courtney, this court said that because plaintiffs had similar diagnoses and essentially the same surgery, that there was a common question of law or fact. I would present to the court today that this is not the same as Courtney either, because these were not similar diagnoses and these were not essentially the same surgeries.
So what if the commonality is simply the commonality in the behavior of the defendant? So regardless of the ailment of the patient, that the commonality is the behavior of the defendant?
Mm-hmm. I would still
How would you respond to that?
My response to that would be it's still left to the trial court to make that determination, and that is not what happened here. Here, the trial court did not consider whether Ms. Boggs, Ms. Koch, and Mr. Stallings had a common question of law or fact based just simply on the legal theories that they were proffering and the defendant's alleged misconduct. Rather, the trial court deferred to plaintiff's counsel to make that determination. And what we're seeing here then is that there are weaker cases being attached to potentially stronger ones that can then fly under the radar without a true common question of law or fact.
Mm-hmm. Is it that the trial court ultimately determined that the trier of fact would be able to treat these cases distinctly? Is that the heart of what the trial court determined?
The trial court in Densler just decided to consolidate these cases.
I'm talking about in this case.
There's nothing on the record as to why the trial court thought that there was a common question of law or fact that would be sufficient for these 3 cases.
I recall reading that the trial court made some sort of statements that they believed that the jury would be able to to distinguish the facts, and in the post-judgment determinations that they in fact did be able to distinguish these cases, which is what I'm calling treating the cases distinctly.
Well, I don't have that exact citation of where that occurred in the record, Your Honor, before me, but I think that what we're seeing here is that in fact the jurors could not distinctly tell these cases apart, which is why we then resulted in both an inconsistent verdict and a non-unanimous verdict. In Worley, this court recently said that non-unanimous verdicts demonstrate that there is a close case and that you can't fully say that.
I want to make sure, and I had this conversation with the counsel on a different case yesterday. I want to understand what lenses I'm putting on, okay? Like, what is the issue? Is the issue that the trial court didn't articulate a determination as to why it was okay for the jointer, or is it that they did articulate something, and maybe it was that the trier of fact was able to treat it distinctly, and that the record establishes otherwise? Because those are completely different arguments.
The first one, Your Honor, that the trial court did not clearly establish why there was a common question of law or fact for these 3 plaintiffs to be tried together.
Okay. And so your position is that that's something that the trial court must articulate. So in essence, are you arguing that there cannot be meaningful appellate review absent that articulated determination?
I am, Your Honor, because absent that articulation, there's a silent record before the court, and that does not afford meaningful review, and it should not be left to plaintiffs' counsel to determine which of their cases they want to consolidate for trial.
And is that your position today, or is that your position in your brief?
Both, Your Honor.
Okay. All right.
I'd like to turn a little bit to the non-unanimous and inconsistent verdicts that I've mentioned.
I do have one more question, and it's rooted in my concurrence in the Fenner case. Are you familiar with that?
Yes, Your Honor.
Okay, so there I talk about the difference between a pre-judgment determination and a post-judgment determination on joinder, okay? And so a pre-judgment determination, I think we can all agree, is going to be rooted in Civil Rule 42, right? So the question is, on a post-judgment determination, where do we begin? Do we begin in Civil Rule 42, which it seems to be where everybody's going?
I
Civil Rule
think
42 really applies in the pre-judgment. So do we begin there, or?
I think we do begin there, because I think you should always be looking to the plain meaning of the rule that's applicable, and here that would be Civil Rule 42.
But Civil 42 is cautioning as to when and how a joinder is relevant. In this, your argument at this point is the joinder determination was already made, and what you're saying is that in making that, and in the actuality of what occurred in the case, that it had some sort of harm to your client. So
I'm arguing that the
so
joinder
that error,
determination was
that error
not.
has to be founded in some rule that that can still go back to 42 ultimately in some way, shape, or form. But whenever we're looking at error, that error has to be rooted in some rule of that for the post-judgment of that error.
Well, for one part of what you mentioned there, Your Honor, I'm arguing that the joinder here was not proper, not that there was joinder, so we need to look somewhere else. I'm going back to the beginning as well, that the trial court, this was not properly joined before the trial court. They didn't make that determination.
So
And
to you, it makes no difference whether it's pre-judgment or post-judgment, even though your argument in post-judgment is arguing what you perceive to be the actuality, and in pre-judgment, you're arguing what you perceive to be the possibility.
I think in pre-judgment, I'm also arguing the actuality that these cases did not share a common question of law or fact. And if we didn't want to start at Civil Rule 42 and just for post-judgment and wanted to just look to I would just encourage the court to look to the record, and that there is in the record a non-unanimous jury verdict regarding Ms. Koch and Mr. Stallings, as well as an inconsistent jury verdict regarding fraud.
I get what you're saying, because if your argument is merely that there was no commonality, then that commonality is going to be absent whether it's pre-judgment or post-judgment, okay? But if your argument includes actual prejudice, then of course, then we're dealing with post-judgment. And I think what you said earlier was really you're focused on the commonality. Okay.
Yes.
Thank you.
Your
Well,
Honor.
so the jury came to different outcomes with respect to these individual plaintiffs, is that right?
Yes.
So despite the consolidation, the jury was able to make a distinction that some of these situations were different than the others.
I think what the jury verdict reflects is that, again, these weaker cases are flying under the radar. Regarding Mr. Stallings, some of his jury verdicts were only 6 votes, the lowest number that you need to return a favorable jury verdict.
Right, so the concern, my understanding of the concern of consolidation is it's all getting kind of mashed together, and the jury's not making these distinctions. And it appears here the jury actually was able to distinguish between each of these plaintiffs. So where is the prejudice that resulted from consolidation if they were able to make that distinction?
I think that I would direct this court to its recent decision in Worley, where the court said that these non-unanimous verdicts indicate that this could have gone a different way if there was not the prejudice. In our briefing, we've also submitted 8 other potential errors. I would argue that because these were joint trials, those other prejudicial errors impacted and affected what the jury heard and was able to take under consideration.
But with respect to consolidation, the jury was able to distinguish between these 3 individuals and their situations.
I would still submit that the jury, at least one juror, was confused. We had an inconsistent verdict regarding Ms. Boggs with fraudulent misrepresentation. 7 jurors voted that there was fraudulent misrepresentation, but then on the question of proximate cause, 8 found that there was proximate cause. There was a recent case by the Ohio Supreme Court that said that these type of verdicts are illogical. At least one person on that jury was confused. And then I think what we're seeing with the non-unanimous verdicts, it could also tie into our punitive damages here, where we had identical punitive damages of $9 million. So I would not say that the jurors were able to distinguish these three. The purpose of, as Mr. Statman said at trial, the purpose of these punitive damages is to punish for, And Mr. Stallings, a 75-year-old former Navy veteran who served decades as a postal worker, I would not think would be entitled to a $9 million punitive damages award if his case would have stood alone.
So you're past your time, but I recognize that there was one more argument you wanted to make. So I'm going to give you a minute to make that argument, and I will be equally liberal on your side, okay?
Thank you, Your Honor. I appreciate that. The other argument I wanted to mention was that in this case, what's unique is we had testimony about surgeries that the trial court explicitly said would only be considered for factual background, and plaintiffs violated the trial court's instruction. There was testimony from Dr. Sani about a pedicle screw in Ms. Boggs's spine from a prior surgery she had that was not at issue here, and it said things of this might be a post-operation complication of the surgery at L5S1. And while the trial court did sustain the objection to this statement and others, it did not give any instruction to the jury to disregard or why that would not be considered later on. And in effect, that was a highly prejudicial statement that gave the impression that Dr. Durrani is botched the first surgery, which in turn could have caused the second and the third. And tying that to the joint trial issue, then we see that it gives the impression overall that Dr. Durrani is not a medically competent doctor. Those surgeries, that testimony is highly prejudicial and did impact the way the juries then saw what their $9 million punitive damages should be to punish.
Okay, thank you.
Thank you, Your Honor.
Good morning, Attorney Statman.
This is now reminding me of the Yes rock band song, "Welcome Back, My Friends, to the Show That Never Ends. Come inside, come inside." As I was just here last week with almost the identical list of
I thought you were going to quote Comfy Couch when you said the show that never ends.
So,
I was waiting for Comfy Couch because I know the lyrics to that one.
counsel said that the plaintiffs decide which cases get tried together. That's not true. Both sides submit their lists of what ought to be tried together, and Judge Reese makes the decision. So we are not in 100% control.
So when does that happen?
That happens every so often.
And it's just the trial court makes some sort of
Trial court-
selection from the two lists?
Trial court says we are running out of cases. I would like you all to submit your list for the next trial session beginning September 1st through February 2nd. And we submit the names and groupings, and they submit the names and groupings, and he decides. So it is not a decision of the plaintiff solely how these things are grouped.
When he does the groupings, does he set forth his rationale, or does he just simply say, okay, these are the cases that are consolidated together?
He sends out a notice of the grouping and then says, based on his review, this is how he thinks they should be grouped. Doesn't go through them one by one. And I think one of the reasons he doesn't go through them one by one is like in this case, as in 125 cases with little tweaks occasionally, all the jury instructions are identical. Identical. We've had some tweaks about Dr. Durrani's lack of presence and maybe one other, but otherwise the jury instructions are identical. So the law in the case is identical. The experts on both sides are identical. We use the same experts, Sometimes one doesn't come and one does.
Well,
They
the
use-
argument here, as I understood it this morning, is that the facts themselves are not identical, and that should defeat the joinder.
Well, this is all part of the facts. Now,
Well, the
if
facts,
they're
its
saying,
relationship to the medical conditions related to the
Of course they're
plaintiffs.
identical. It's a lumbar surgery. They're both lumbar surgeries. They may have been done at L2 and 3 and 3 and 4, but they're lumbar surgeries bringing about, if you believe Dr. Durrani, the same result. And if you go a step back into the evidence, you will see Dr. Durrani's letter where he makes the recommendation.
Does it
for-
matter that the medical history of the patients would be different?
Everyone has a slightly different medical history, no matter who they are. If you go back, and I'm sorry I don't remember the name of the case, Ben was going to look it up, the case that you consolidated 7 eye surgeries. The medical history of each of those plaintiffs as to how they ended up getting that surgery from that doctor were all different. But it was the same medical treatment on their eyes. And it wasn't all right eyes or all left eyes. It's a combination. So you're never going to get absolute perfection, but you're going to get enough commonality that it works. And then you have to look at other issues besides that. And there's still 400 cases to go, and we've been doing this 13 years. So the next step in analyzing whether that consolidation makes sense or not is that jurors were not confused. They all have separate notebooks. They all take their own notes on each case. And the fact that you got some jurors agreeing with the plaintiff and a couple agreeing with the defense shows they're all exercising their independent judgment, not that they're confused. Some believed the testimony, some didn't. I think that goes to an appropriate consolidation. Not every case is going to be won 8-0. There's going to be jurors that see things differently. And clearly, if the consolidation somehow prejudiced Dr. Durrani, it would all be weighted in favor of the plaintiff, and we would see 3-8-0 verdicts. This court, through other justices sitting over the last several weeks, finds nothing unusual about matching punitive damages. Given the fact it's punishment, the jurors are punishing him the same for doing unnecessary, medically unindicated surgeries. And none of the previous judges have found anything odd about that, given the fact that it's not tied to things like pain and suffering and someone's degree of disability. So I don't think that shows any prejudice coming out of the consolidation as well. And then when you delve deeper into the factual similarities, besides same experts, besides lumbar surgeries, besides the same surgeons, the same witnesses, they all needed surgery. They all had similar impressions. If you read Dr. Durrani's letter, where he gives impressions and then plan, all those letters are similar. Now, the level may have been changed from L3-4 to 4-5, but you read the impressions, they're all the same. Substantially disabled, spondylolisthesis.
Counsel, what about this idea that 3 versus 2 is a distinction with a difference?
That 3 versus 2 makes a difference?
Right.
Well, you all have ruled in the past that 7 doesn't make a difference. So I don't see 3 versus 2 making a difference, and in federal court, we did 6. So I don't see any difference. Once the jury has decided that they're going to listen to each case separately, which we have seen no evidence that they have not done that, everything seems to be fine.
Is there any limit?
Is there any limit? I think there's a limit about what you can manage and how long the cases take. A 6 Durrani case takes 6 weeks. A 2, a 3, and a 1 all take about the same time, 2 weeks.
So it's just logistically?
Yep. Yeah, and I think that if you had 40, well, then maybe it would be 40 separate notebooks would be a lot for a jury to manage. So I think there is a point where it might become absurd, but we haven't gotten anywhere close to that, nor do we have jurors in post-trial discussions going, boy, that was the hardest thing I ever did. They don't seem to have any difficulty, and the judge talks with them about that every time. And that's why he came up with the separate notebook, to make it even easier. So I don't think that there are any problems as it relates to that, and I don't think that the jury verdicts and the Court of Appeals decisions are inconsistent. And I make that finding based upon an action you all took when Dr. Durrani's attorneys asked for an en banc hearing. It was denied. My belief as to why it was denied is it appears to me from each decision you are making, you are looking at the facts, and each one is a factual determination by the Court of Appeals as the law was presented to the jurors and how they reacted to it. And that's why they just didn't get a blanket en banc, everything's reversed, we're going to do it all by the decisions in this case, and this case, and there aren't going to be cases where Dr. Saini is found to be one way or another, or Dr. Tayeb is found to be one way or another. They're looked at on an individual basis, as they should. The problem is that we suffer every day is that the Durrani side does not look at any case on an individual basis. They don't want to hear about individual settlements. It's all part of the record in this case. And all they want to hear is about group settlements. So it doesn't, and the group settlements aren't $2 million for the L5 surgeries, $5 million for the thoracic surgeries, $10 million for the cervical surgeries. They're not dividing them up. They're lumping them all together. And quite frankly, here we are on consolidated arguments. So consolidation isn't a foreign concept to you all because the cases are so similar. And if you note, the appellant didn't get up here and tell you how the intricacies of the L4-5 surgery differ so much from the 3-4 surgery, there's no way they should have been put together. Those surgeries are relatively the same, just on a different level. Now, if it were a C1, C2, and you're dealing with the rotation of the cervix, which has no disc, has vertebrae that don't look like a single other vertebrae in the spine, and are responsible for turning the head, well, that could be a horse of a different color. But we're not talking about an Ehlers-Danlos syndrome case or hyperrotation of the C1, C2, because that's a completely different function. Those vertebrae, they don't look anything like the ones, I'm telling you, if I had an L4, an L5, and an L3 sitting here, and I just set them up on your desk, I wouldn't be able to tell the difference between any of them. But if I had a C1 and 2, because they don't have a disc, one's a circle, and the other is the axis that the head spins around. Completely different, and a completely different type of surgery. So here, it's just kind of degenerative disc disease type surgery, and that's what they do. And it's similar. The doctors are similar. Everything's the same. They claim the recovery procedures are similar. The post-recovery words and comments of Durrani, you could interchange the names on the letters. The pre-surgical letters, you could interchange the names on the letters. It's unbelievable the level of similarity that exists in this case.
Attorney Statman, I want to ask you some questions of law, but before I ask that, were there any other assignments of error that you wanted to argue this morning?
Only if you think that you need my explanation on something they talked about. I
Okay.
may have
So
covered
let me
it.
defer to my colleagues in the event that they have any questions on any other of the assignments of error. Okay. I have some questions of law, okay? So with regard to Rule 42, and I'm going to look at Rule 42, and I'm only looking at this point on any pre-trial determinations, okay? So when when the determination is being made, in this case, it was for joinder for the purposes of trial, okay? Absent the invocation of the B section, which clearly did not occur here. There was no request to separate any issues out or anything like that, right? Because the B section does talk about prejudice. In the A1 section, is prejudice at issue in the determination of the joinder?
Well,
I'm only talking about pre-trial determination, not post-trial.
all I can tell you is in looking at it from the appellee's point of view and watching how they do things, they make a general objection to joinder. They do not point out any specific area that would be prejudicial. Their belief is trying two medical malpractice cases together against the same doctor leaves an impression that he's not a good doctor.
I mean, they invoke to a certain extent 403, 404 evidence rules. I can't remember if they do it before or after, but they're basically tapping into the idea of propensity determinations or propensity behavior by joining these different matters of these different patients into the same trial.
Well, except that propensity is left out of cases moving forward on your ruling on tie-up until I take a more
But my
detailed-
question is much more fundamental than when we get into their argument, is simply whether prejudice is part of the inquiry and determination when a trial court is looking at joinder or consolidation, okay? And only the A1 section is being considered, and the B section is never invoked.
My feeling is that he considers prejudice every time he makes a ruling, and as a matter of fact, he is very careful in the jury instructions to make sure that each of the jurors is trying
So you believe
each
that
case.
prejudice is part of A1 regardless of whether the language prejudice is in there or not?
Yeah, because I think it's covered by the jury instruction where he is specifically telling them they are to consider each case on its own merits. One does not tend to prove the other and vice versa. And that's right on that issue. I don't think people in the legal profession have to say all the words to make the words concept applicable, if you understand what I mean.
Okay, so then my
So-
next question that I'd love to get your thoughts on, okay, is, in this case, we had a pretrial determination on joinder, right? Then the trial takes place. We have an outcome. And then there was a motion filed post-trial, which was arguing error in that joinder, right? For the pretrial determination, it says here that the court may join, right? So once the trial court has made that determination, which the rule gives the trial court the authority to make that determination, do we solely go back to 42 post-trial? Because isn't the post-trial argument that in fact there was some sort of harm?
Well,
So, it seems to me that, and I'm not saying that 42 is not part of the landscape in the post-trial, but it seems like it begins with some invocation of a civil rule of error that despite the fact that the court allowed that the trial court was authorized to make this joinder, that in fact this joinder did create error. So
he
to go
looks-
back to the may language seems wonky to me. It's
But
that
he-
being the beginning of the argument when it's post-judgment.
But he looks at that every time they make that motion. And based upon,
But I'm asking you your position as an issue of law.
you're not seeing what?
I just want to understand your perspective as an issue of law.
From my perspective, he covers that post-trial when he looks at the verdicts and determines that the verdicts are fair and reasonable and are not the result of any type of passion or prejudice. And if the occasional error he sees in a verdict, if it's something that can be fixed by the jury by further deliberation, he sends them back. So I'm not really sure what you're saying.
Okay,
He
and
checks,
that's fair, because this is like,
no, but he checks the verdicts for something that would be obviously prejudicial. For instance, if they said, well, we're not really sure about this case, but boy, he sure blew it in those other two, so he probably blew it in this one. You know, when they write the explanation, we've never seen anything like that.
okay. Well, thank you. Thank you for considering my questions.
All right,
I
thank
appreciate
you.
it. I don't, unless there's anything further from my peers. Okay, thank you so much.
I want to touch briefly on your line of questioning that you were just doing regarding the questions of law. Rule 42A does not mention prejudice, but there's inherent prejudice in joining unrelated cases, and Rule 42A sets the minimum requirement to consolidate. But as you mentioned, it's a permissive may and not mandatory. And so here, the plaintiffs did make the decision, contrary to their assertion. If we go back to Densler or the mandamus actions where Judge Reese set these three for trial, he said he was going to defer to plaintiffs to make the decision to consolidate. And in plaintiffs' own motion to consolidate, they said that it was proper because there was a common issue about the L4, L5 joint. There was no mention about L3, L4 being similar or the same. If it was, that would have been included in their original motion to consolidate. It wasn't, because L3, L4 is distinct from L4, L5. And
Also, other than the location, how are those two levels of the spine different?
the human anatomy is distinct in every part. To say that because it's two areas of the spine that are close to each other, that they're the same.
Well, he made the point that the elements of the lumbar spine are different than the cervical spine.
And while
Do you agree
that's
with
true,
that?
I do agree that the
And
cervical.
what is the difference between the levels of the lumbar spine?
I'm not a medical expert to know the exact differences between L3, L4, and L4, L5, but
But you're
they have.
suggesting it makes a difference.
It does make a difference. They have different names. They're different anatomical structures because they're not. While they may both fall within the lumbar portion of the spine, they're not the same vertebra. They require different technique and diagnoses, and they are not the same. And here, not only were the areas of the spine different amongst the plaintiffs, but as I mentioned before, the diagnoses, the medical histories, and all of that plays into how Dr. Durrani approached, or his approach in performing these surgeries. I think an analogy could be an attorney that had three different clients that they were representing, but they presented similar claims but not the same. We wouldn't say that those were all identical claims because the attorney-client relationship is unique for each client that we encounter. The facts are different, the claims are different, so L4, L5 is not the same as L3, L4.
But one of the claims is that Dr. Durrani deceived these patients.
Mm-hmm.
And so does it make a difference whether he deceived them about L3, L4, or L5, L6?
I mean, I would say that it doesn't make, or it does make a difference because he's recommending different surgeries for different areas of the spine.
Both, at least according to the plaintiffs, both deceptively.
Well, and I mean, I think what we can see here, the jurors, there was confusion as to that point. That's why Ms. Boggs's juror verdict on the exact fraudulent misrepresentation was inconsistent. So even the jurors themselves didn't fully understand if there was a difference here in how he represented what surgery was required for these different portions of the spine. She was the plaintiff that had both a surgery at L3, L4, and L4, L5.
The process that Mr. Statman described, where both sides submit kind of their lists of cases that they want to get consolidated, in this case, or with these cases, I assume when you got the grouping back, did you make some new objection about the grouping?
The objections came in response to, yes, the Denzler consolidation. There was also a motion in opposition with objections to a later motion to consolidate from plaintiff's counsel. But there was an objection when these three were first grouped in the Denzler case, which is in our supplement before the court. And I think if there's no further questions from the court, I would just ask that the court find that there was prejudicial error in this case. It was not harmless, one reason being the consolidation of a three-plaintiff trial. In addition, that the court would apply its recent decision in Fenner regarding set-off, and that it would remand to the trial court in accordance with its findings.
I understand that, but you just confused me because you just finished saying it's not harmless. So you're invoking Civil Rule 61.
I'm sorry, I may have, I must have misspoke, that the prejudice was harmless.
I mean, but I'm sorry.
I'm sorry,
But-
yes.
But regardless, and I may have, regardless of who misspoke on that, the
The
point
prejudice
is.
was not harmless.
But the point is now you're invoking Civil Rule 61, and when I asked you, is this all about Civil Rule 42, even though we're looking at post-judgment, you were quite clear it was. But you really are invoking Civil Rule 61, which you could only invoke post-judgment. You cannot invoke that pre-judgment, right?
Yeah, I apologize. My
So-
statement about the
It's okay,
prejudicial.
but this is like the confusion that I have with the way that these cases are being presented. Because all I'm hearing about is Civil Rule 42, but yet you're complaining of error that's post-judgment, and that has to be rooted somewhere in post-judgment. It doesn't just go back to Civil Rule 42. Do you
Yes, I agree with Your
That's the heart
Honor.
of my whole questioning, but we're good.
Well, I
We're
was
good.
going to, just to clarify briefly, if I may, when I'm saying the prejudicial errors, I'm referring to the 9 errors that we've submitted in our briefing, not just,
Because
the-
prejudice is defined in Civil Rule 61.
Yes.
I mean, there is a discussion of prejudice there, and yet we're talking about prejudice and rooting it only in 42, but this is a post-judgment, but it's all in my, it's intended to be articulated in that concurrence in Fenner. But thank you so much for both of your arguments
Thank
this
you.
morning. We'll take the matter under submission and issue a timely decision. And we're going to just sit here and do a good old switcheroo. I hope everyone has a wonderful afternoon. Counsel, you can go ahead and come forward. Good morning. All righty, so, okay, there we go. I was wondering, how are you doing?
I'm here.
Was there a lot of traffic this morning?
The rain. Last night we were on the highway and I came from Oxford, so it's
Oh, my, okay,
a
yeah,
lot.
yeah.
Good.
Unfortunately, when it hasn't rained for a while, all those oils rise to the surface, and we have a bunch of accidents. Whenever you're ready.
I'll reserve 5 minutes for
All righty.
May it please the court. This matter, this case, I believe, sets an unfortunate precedent if allowed to proceed, continue as is. Due to the course of this case, as you're aware from the briefs, a medical expert witness was not sworn in at the time of giving his testimony. As pointed out to the court after the testimony, there was a motion to strike the testimony as not being sworn. The judge rejected that and then ordered counsel for the defendant to call the expert witness on the phone and swear him in out of the presence of the jury.
Wouldn't the time to object be when the expert started to testify and it was clear he hadn't been sworn in yet?
When he was testifying?
Before he started to talk, it was clear he hadn't been sworn, right?
Because I'll tell you, there was this unusual circumstance for me anyway, in that this was by Zoom. So we're dealing with the Zoom. I think you may be correct that it should have been pointed out perhaps by the defense that their witness had not been sworn.
Well, what about the plaintiff?
The plaintiff, I think, has the same duty, but I don't think that's permits it to go forward as unsworn testimony.
But should the plaintiff be allowed to?
Timely object at that time.
Should the plaintiff be allowed to sit on his or her hands and allow this testimony to proceed, recognizing that it hasn't been, the witness hasn't been sworn?
Quite honestly, it wasn't apparent until into the testimony that we realized the doctor had not been sworn.
I'm sorry, I'm confused. Why wasn't it apparent when he hadn't been sworn before he started to
We did not
talk?
recognize that he had not been sworn immediately, nor did anyone else.
But you would agree that raising that objection then would have allowed the court to correct it then?
Could have corrected it, yes.
So I
But the court-
think the issue is whether the objection was timely, because my understanding is that, and we don't have the whole transcript to this trial, which is kind of problematic, but my understanding from what the judge said is that the plaintiff waited until after another witness testified before they even raised the issue. Is that what happened?
You know, quite frankly, I don't remember.
Okay, I mean, that's what the judge said. We don't have that. You made the motion off the record at a sidebar that you requested after Dr. Spittler testified, is what the judge said. So it sounds like this was not even objected to immediately after the witness testified.
That would be perhaps accurate.
Okay, so then, was the objection timely? Because if not, we have to do a plain error analysis.
I'm thinking.
Okay.
It still was incumbent upon the court to swear in the witness.
Correct, but we cannot, the way we look at error below changes if there's not a timely objection made, right? This court. So we would have to apply plain error.
That's true.
Okay, so you agree that our standard of review is
Would
plain
be
error?
for plain error, yes, and that's what we're suggesting.
Okay. Then I have another question. How do we apply plain error when we don't have the entire transcript to look at to see if there was some sort of prejudice that came out of this?
I'm not sure what else would be in a transcript that would relate to that. I think our argument is, and plain area is the court's application, how it approached the problem when it was presented, and then subsequently how the court handled the motions to set aside the jury verdict. 'Cause
But
we have
isn't
no-
there a prejudice, don't we have to do some sort of prejudice analysis here in determining whether there was plain
I
error?
think you do in terms of what the jury was considering, and was it prejudicial to the plaintiff in this case to allow that testimony to be heard. The judge could have corrected at that point when it was brought to his attention to inform the jury to strike the testimony, which we asked for, of that expert witness.
What would have been the remedy then for that witness to re-testify under oath?
That wouldn't be my choice, but that could have happened.
Okay.
but it didn't. And I think the judge suggesting that he can swear in a witness over the telephone outside the presence of the jury is further error in this case.
So when can you fix, if, trials are fast-moving, you said it was Zoom and everybody was blah, blah, blah. If you forget to swear in a witness, when can that be fixed? I mean, if nobody realizes until after the witness testifies, then what?
Well, I think at the point that we raised the issue, the court could have suggested that the testimony be case had not been closed.
Redo it.
Redo it.
That would be the only way to do it.
I think that's the only way you can do it.
Okay.
There's a constitutional right on, as to testimony must be sworn before given. There's a statute on it. There's rules on it, and it didn't happen in this case. And if this case were to go forward, I think there'd be a bad precedent set saying that it can be, we failed to swear, but that's okay. Let the testimony go. This isn't a minor error in terms of, I don't know what the jury relied upon. This testimony either was what they determined the case on, or it may have been just really bolstered the case. But this doctor went first of the witnesses, so it was probably that they relied upon it,
So what,
unsworn testimony.
what is your position as to what the trial court should have done when it came to everyone's, because no swearing in has taken place before the testimony, no swearing in has taken place during the testimony is now complete, right? So what is it that what is your position as what is it that the trial court should do under those circumstances at that?
I think the trial court could have recalled the witness
Okay?
and let him testify under oath.
And
That's
so
exactly what he
reestablish
just
it.
testified to, sorry. Just repeat exactly what he.
Yes, could have been.
And how is that different
I don't
from?
know.
How is that different from having him confirm under oath that his testimony was true and accurate?
I don't know that he might have given the same testimony under oath. I don't know that. We don't know that.
Okay.
But he did confirm that the
He may have-
testimony he gave was true and
He was
accurate.
aware he wasn't under oath.
I'm sorry?
The witness was aware he wasn't under oath.
No, my question was when he was called on the phone, he confirmed that the testimony he had just given was true and accurate, right?
I think he was just sworn in. It was a highly irregular procedure.
Correct. And isn't the point to be able to correct these highly irregular procedures in the moment? That's why we require objections to be made timely?
I think we did make a timely objection before it was submitted to the jury, that the defense had an opportunity to have him sworn in front of the jury and give his testimony as such. But it didn't happen. It wasn't that we waited till the close of the case. We did it before the close of the defense's case. I think this is
You have 1 minute left, counsel.
pretty much. the
I'm sorry, I
script.
missed it. Was the telephonic swearing in where the doctor said that his testimony was the truth, the whole truth, and nothing but the truth? Did you say that was done in front of the jury?
No.
It was
not.
outside the presence of the jury.
The jury
Okay.
was not present.
All right.
Thank you.
Thank you.
Good morning, members of the court.
Good morning.
This is my second one where I've had to thank the court for its indulgence in changing the schedule.
No worries, no worries.
I appreciate that.
We're here to serve you.
Your Honors, if I may, I think to address the last issue that Mr. Green brought up about the fact that he was sworn outside the presence of the jury, I think this court recently addressed a similar issue in the Edelstein case. Judge Moore, I think you were the author of it, where in juvenile court, a staff attorney was swearing in witnesses outside the presence of the court itself, and this court said that that was sufficient to do so.
Now, that was pre-testimony.
That was pre-testimony, I agree. But the court also went on to say in paragraph 57 that the proper time to raise an objection will be prior to each witness's testimony.
I mean, it seems to me that the first question is timeliness, that then leads us to what is the standard of review.
That's correct. And let me, I guess, address first the timeliness, because that might be the low-hanging fruit here that we have to deal with.
Well, I think it's the first hurdle.
It
It's
is
the first inquiry, not hurdle, but the first inquiry, because that, again, determines the second, which is the standard of review.
That's correct. We do not believe that the objection was timely made, and we outlined why in our brief and also in our response at the trial court level in trial docket 54, where we outlined additional bases. And what occurred in this case is unusual, no question about it.
And you're not saying it was an error, per se, not to, that there was some form of, that the swearing in should take place before the testimony.
Procedurally,
Okay.
the swearing-in should
Yes.
take, yes, 100% agree that is the way it's supposed to happen. We had some significant technical issues. For those of you who are familiar with the courthouse across the street, sometimes technology doesn't work that well. Perhaps it's the solar eclipse, I don't
I don't know, perhaps it's those thick walls,
It
too.
is the thick walls. Unfortunately, Judge Jenkins has some windows, but I guess somebody didn't have their finger up in the right spot. We did have quite a bit of difficulty having the hookup occur. It was slightly chaotic in the courtroom that morning.
Okay.
Dr. Mathani and Dr. Spittler, our two experts, had been ready to testify in person the day before, but due to a medical emergency by plaintiff's counsel, everything was moved back. They were not able to appear in person, which is why we had to arrange it this way. The court was attempting to set up the Zoom. We had it set up, we tested it the night before, everything worked. Tested it earlier that day, everything worked, and as one can expect in that courthouse, it did not work when we were supposed to have it work. It was slightly chaotic. Judge Jenkins asked the witness to proceed, asked me to proceed. To be honest, I did not pay attention to whether or not the bailiff swore in the witness, and frankly, I don't think the court heard it either, because at a sidebar, when this conversation took place, neither one of us could recall whether or not that had occurred. We are going under the assumption that he was not sworn in, first of all. So let's take the assumption that he was not sworn in.
So the fact that that transcript is not part of a record, are you saying that that has no relevance?
It is not part of the record because that was a sidebar outside the court reporter,
Okay,
the conversation we had at sidebar.
so that's why, okay.
There is no transcript of that, and that's why it's outlined in our brief on trial docket 54 at the trial court level, and also raised by Judge Jenkins in his response.
Okay.
So wait, but you're saying we also don't have the doctor's testimony, or do we have the doctor?
You have Dr. Mathani's testimony.
Okay, and so we know the doctor wasn't sworn in.
We know on the transcript that Dr.
Okay,
it does
so we're not
reference
assuming that he wasn't.
That's correct.
Okay, we
It's-
know he was not sworn in, but we just don't know when the objection precisely occurred, except for what the judge said on the record.
There is no transcript of the sidebar, but that objection occurred after the next witness had testified
Right.
and been released.
And that's what the judge said
Yes.
on the record?
Yes.
Okay.
And
We-
the doctor, I'm sorry,
Go ahead.
the doctor was deposed.
He was deposed.
And he was-
Actually, I apologize. He was not deposed. He produced a report.
Okay. And was that report accompanied by an affidavit or anything that would make that sworn testimony?
No, it was just, the report was filed with the court as part of the court's pretrial orders, but Dr. Mathani relied on his testimony and certainly the contents of his report, since he's subject to the contents of his report. But what occurred here, in terms of the timeliness and the basis for, and the argument about timeliness, is that, first of all, if Mr. Green was the only one who heard the fact that he was not sworn in, the time to raise that was at the time this was occurring.
Okay.
I think.
I want to clarify something because I'm a little bit confused, okay? So we've got the testimony of the doctor, and in that transcript, there's nothing as evidence that there was a swearing in.
That's correct.
There's no one's disputing that there wasn't a swearing in, right?
That's correct.
Okay. And then you mentioned, well, we don't have the transcript of the sidebar.
Correct.
Because there is
There
no
is no
transcript
transcript.
for sidebar. Okay, so Was there an objection? Or was there
At
somehow a sidebar?
Only at sidebar after Dr. Spittler, the next witness.
How can there be an objection on sidebar when sidebar is not part of the record?
Well, that's an issue. There was no record. What happened is the parties approached.
But how can there be an objection at sidebar if sidebar is not part of the record, unless when we come back to the proceeding, someone says, okay, can you put that information into the record? So
I see what the court's saying.
okay, so my question is very fundamental. Was there an objection?
Arguably, no, if there's no transcript of it. There was, but there's no transcript of it. I don't know how to.
But again, if there was, but it wasn't brought back into the record, then was there?
According to the record, there was no objection.
Because the sidebar is not part of the record. The court reporter's not there going,
That's correct.
of whatever it is that's going on in sidebar.
correct.
That's why it's called a sidebar. So I am confused.
Well, what the court asked us to do, because of the confusion over the swearing in, was to contact Dr. Mathani, and we had him sworn in. And in the transcript that you have in front of you.
So I don't know if there was an objection, perhaps there was an acknowledgement. An acknowledgement is different than an objection.
I get the court.
And I don't know if it, and I haven't even thought about how does that play into standard of review. You know, I'm just trying, because I said the first thing is timeliness, the second thing is, so timeliness is like, absent an objection, there's an acknowledgement that
Well, and let me move on then to the next part, which is waiver. And I think, as the court pointed out, and as addressed with Mr. Green in the transcript, it says that after Dr. Mathani was sworn in, Mr. Green was asked, "Are you satisfied?" And the response was, "Yes, I am." That's before he asked again for a motion to strike the testimony, but counsel admitted that he was satisfied with the manner in which the court handled the testimony. If it had been the other way, we would have put Dr. Mathani back
So
on
my
and done it
question,
all
so
over.
now my next question based on that, is our standard of review plain error or is it just waiver? It's waived, we're done. Because if there's an acknowledgement of satisfaction, does that then bring us to plain error nevertheless?
I do not believe that this court gets to plain error.
And why is that?
Because, number one, there was waiver.
Because obviously for civil, it's not just plain error, there has to be, it's more
That's
than that.
correct. I think under the fact that counsel was satisfied was a waiver of that position. And I think if the court considers its other decisions out of the first district, the court does not seem to imply that this is a plain error position. And specifically in the Scott versus Wells case, the court discussed the fact that there was waiver. There was an issue of waiver when the matter was not brought timely to the court's attention. And in this case, it's a little bit more because there was an acquiescence that the court was satisfied, or the counsel was satisfied. I think the bigger issue is the In Re GW case, 2020 Ohio 3555. And in that case, there was, none of the witnesses were sworn in. But in paragraph 21, the court stated that unsworn testimony is competent when opposing counsel neither requests that a witness be struck nor makes a timely objection. And I think that applies specifically in this case.
Well, that's a plain error case, right? GW?
The argument attempted to, well,
That's not a waiver case. That's looking at plain error, the plain error standard.
well, then if the court, I thought it was a waiver, but even under the plain error, if the court applies plain error, the court needs to
I think the
consider.
key here is that there was an acquiescence, that it was satisfied.
Correct.
That's the basis of my question of the standard of review. It's not the error itself, but then the acquiescence that the error was corrected.
There was an acquiescence that the error was corrected, which I suppose. then
Meaning
gets-
saying there is no error.
There is
So
no error.
there's no error.
There's
So
no
so at the trial court, there's an establishment that there's no error by the same party that is now complaining.
That's correct.
So, or is this an invited error, which is not a standard of review, it's actually a bar of review. So is this an invited error situation?
I believe it is. I do not believe that this issue belongs before this court.
Can I ask you, though, I'm looking at this, the part of the transcript where there was this acquiescence, where
Right.
Mr. Green says, "Yes, Your Honor." But the transcript goes on,
That's
right? And he then talks about how they made a motion to strike, and then the court said, "Well, you didn't make the motion until after the doctor testified," and he talks about all of that. And then Mr. Green says, "I'm making a record that we have moved to strike the testimony of the doctor. He was not sworn in." And the court says the motion is noted, the motion is overruled. So with all of the rest of that, how is that waiver?
If the court is then to look at his motion to strike as what the issue is, then we get down to a plain error argument.
Okay.
And under the plain error doctrine, as the court has outlined in the Goldfuss versus Davidson case, it's extremely rare, it's to be applied only in exceptional circumstances. And the error has to affect the basic fairness, integrity, or public reputation of the judicial process. That is not what occurred here. And under the GW case, if it is a plain error case, and the court is certainly more right than I am, the facts that were taken into consideration in the GW case in paragraph 25 specifically lead one to believe that this court has concluded in the past that this is not an extremely rare circumstance that impacts the fairness, integrity, or public reputation. And the reason is that there's no evidence that Dr. Matani's testimony would have been any different had he been sworn in before rather than at the end. The testimony, albeit the report was not part of the evidence, there's no evidence that his testimony was different from the report that he had submitted pre-trial. And also, he had an opportunity to be thoroughly cross-examined. And those factors were all taken into consideration by the First District to show that it is not plain error. There are other cases that have followed as well, the State versus Norman case out of the First District. And also, I think one needs to also consider the position of Evidence Rule 603 in Wiesenberger's evidence manual, where it specifically states in the commentary that the requirement of an oath may be waived either expressly or by implication, such as when an adverse party goes forward in the manner without inquiry or objection. There was inquiry. There was no timely objection. In terms of the motion to strike, the motion to strike is based on something that was not timely in the first place. I think there's a question whether the motion to strike even meets the standard. One can argue that that would be an abuse of discretion, whether the court should have considered a motion to strike at that time. But even if we get to the plain error, I do not believe that the manner in which the court handled it justifies an extremely rare case that would warrant reversal.
Thank you.
Thank you.
A couple things I'd like to point out to you is, as to the record, the report there was no affidavit. It wasn't presented to the jury as evidence, so we don't know that it was consistent with his report. The jury wouldn't know.
Wouldn't that come out in cross-examination, though? If he testified differently than what he had stated in his report, that would be subject to
It
cross-examination.
may have. No, I'm just pointing out that that record wasn't presented. There was an understanding in the briefing that report had been presented. It had not been. That's all I'm suggesting. As far as the waiver issue, when it says that I said it was acceptable what the judge did, my acceptance was that the judge had proceeded to swear in a witness and had performed that function, but it didn't change what had happened, and that's why we continued to seek the motion to strike. And in terms of the sidebar, I understand there's no record of it, but that's where it was initiated, and you can tell from the conduct of the court as that there had been an objection
Yeah.
raised.
And reading that part of the transcript, the court recognized that that there was a motion, or basically the court basically says, but that's not a motion to strike. So the court characterizes whatever happened at sidebar as not being a motion to strike, but then instructs, so if you want to make your motion to strike now, And if you want to state your objection, you have every right to make the record you need to make of that. And then it was clear, I'm making a record that we have moved to strike.
Which took place,
So,
but I'm just
yeah.
suggesting that
Yeah.
the conduct
Yeah,
subsequent to the.
so I think the record is clear that a motion to strike was made, a verbal motion to strike, and then, but it was made after the testimony of the physician had been completed.
Right.
Okay.
And I further think it's clear that I did not waive our motion to strike or objection.
Okay.
Are there any other questions that the court has for me at this point?
No, but if there's anything further, if you want to say, you still have a few minutes, or if you want to wrap up.
Thank you.
All right. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision, and we thank you both, and wish you both a wonderful afternoon. Thank you.